Mr. Bove.
Thank you, Judge. Good morning, Mr. Davidson.
Good morning.
Barely good morning. My name is Emil Bove, and I represent President Trump, who's here on my left.
Nice to meet you.
It's nice to meet you, too. You've never met President Trump, correct?
Never.
And Tuesday was the first time that you've been in the same room as him, right?
That's true.
You've never spoken to President Trump?
Never.
You have no first-hand knowledge of the business records of the Trump Organization, right?
Only those that I received.
Well, you received some records from Michael Cohen, correct?
Emails and such.
In fact, everything that you know about President Trump came from either TV or Michael Cohen, right?
No.
Much of what you testified to today with respect to your beliefs about Mr. Trump came from Mr. Cohen, right?
I have had no personal interactions with Donald Trump. And either it came from my clients, Michael Cohen, and from some other source, but certainly not from him.
I would like to focus on 2016.
All right.
In that period, you had a strong professional relationship with Dylan Howard, right?
Yes.
And a close personal relationship also, right? Friends?
Fair.
I think you said you'd known him for over a decade, right?
Yes.
How did you guys meet?
I'm not sure.
Was it in connection with your work?
I believe so.
And in 2016, you were talking to Mr. Howard just about every day, right?
I would think, several times a week.
And on the professional side of things, Mr. Howard helped you get business from AMI, right?
Yeah.
You got a couple of matters from AMI, right?
Limited, yes.
One was an employment claim by a reporter, right?
I think so. I seem to recall there was a California matter. They were being sued, and I was being consulted on that.
And there was an entertainment deal with film rights AMI decided not to move forward on?
That's right.
Would it surprise you to learn that Mr. Howard considered you to be a major source of information?
Yes.
And that surprises you, notwithstanding the near-daily contact in 2016?
Correct.
And is part of the reason for your surprise is that you're an attorney, right?
Yes.
And you're not suggesting that you were providing client confidences to Dylan Howard, right?
Not at all.
And then one of the things you talked about on Tuesday and today, I think, was your representation of Karen McDougall, correct?
Yes.
If I understood it correctly, Ms. McDougall did not want to publish an article about the claims that have been discussed here, right?
True.
And you testified in the grand jury in this case, right?
I did.
At the district attorney's office, correct?
Yes.
They were the ones asking the questions, right?
Fair.
And that was in 2023?
I can't recall.
It was within the last 18 months?
Roughly.
In there, you testified that Miss McDougall never really wanted to tell her story to the public, right?
Yes.
And I think you said on Tuesday that she had 3 goals, right?
Yes.
One goal was to rejuvenate her career, right?
True.
And that was your understanding in 2016, correct?
That's true.
And Ms. McDougall had had a real career up to that point, is that right?
She certainly had had a real career prior to, yes.
She had been on magazine covers, correct?
More than that. Yeah, she had a very healthy career.
And that included not just on the Playboy part, but also in the fitness industry, right?
I believe so.
And so by rejuvenate, there was at the time in 2016, when you say rejuvenate, there was ongoing value in her image and likeness, right?
Yes.
And I think you said that one of the other goals was to make money, right?
Yes.
And I want to talk about this a little bit later. That wasn't just her goal, but it was also the goal of some of the people around her.
That's fair.
And the third goal was the one we were talking about, to avoid having to tell her story, correct?
True.
And Ms. McDougall has been clear about that publicly, right?
That's my understanding.
She said that in an interview with Anderson Cooper?
Yes.
And you have described the deal that she got with AMI as her dream deal, right?
I think she described it as her dream deal.
And that's consistent with your interactions with her, correct?
Yes.
And you don't think, tell me if this is wrong, you did not discuss the McDougall AMI deal with Michael Cohen until after it was closed, right?
Yes, that is true.
And I think, sorry to cut you off, I think you said on Tuesday that you reached out to him afterwards as a professional courtesy?
Yes.
But he wasn't involved in any negotiations, correct?
Not that I'm aware of.
Let's focus on Cohen a little bit. I think you said you encountered him for the first time in 2011?
True.
And that was in connection with this kind of blog post on The Dirty?
True.
The Dirty was a web post at the time that focused on gossip?
Fair.
And there was a post with the general substance of the same allegations that Stormy Daniels made subsequently in 2016, right?
Yes.
And at that time, 2011, Gina Rodriguez was Stormy Daniels' manager?
Yes, sir.
She told you that she wanted to get the story taken down?
That's true.
And you described Ms. Rodriguez as sort of a storyboker?
That's part of what she does, yes.
And part of her business, I think you said, was in monetizing stories?
That's true.
Monetizing news?
Yes.
And in 2011, you had already been working with Ms. Rodriguez for a while, right?
Yes.
And so you served as a conduit to help get this story down?
I was asked. I was, in essence, retained to use my best efforts to get that blog taken down, yes.
And you said, in essence, retained. You were, in fact, retained by Stormy Daniels in connection with that engagement, right?
Yes.
And that engagement, the attorney-client engagement, was not committed to writing, was it?
It was not.
And there's nothing wrong with that, is there?
There is not.
That's an ethical practice to have an attorney-client relationship without an engagement letter, right?
Yes.
Now, focusing on Ms. Rodriguez for a minute, is it fair to say that you've had a reciprocal referral relationship with Gina Rodriguez?
I think that's fair.
She sends you some business?
Yes.
Some clients?
Yes.
And vice versa, you send her some clients, right?
I think less so, but perhaps.
Reciprocal, but a little bit one-sided?
I don't know.
You're still fairly close with Ms. Rodriguez, right?
Somewhat.
I mean, you actually tried to represent her in connection with this investigation, right?
Well, I didn't try to. She was contacted by the district attorney's office. They wanted her to come in and give a statement. And I returned the call on her behalf as my client.
The reason I used the word try is that you were instructed by the district attorney's office that they viewed that as a conflict because of your status as a witness, right?
Well, I took issue with that, but yes.
You didn't necessarily agree, but that was the instruction?
I don't agree with the word instruction. That was their
Position?
also position. That was their position.
My point here was the relationship with Rodriguez and you was close enough in 2023 that she still looked at you as someone that she still trusted to be her counsel.
True.
And in 2011, the way that this worked, as I understand it, is that you sent a cease and desist letter to the Dirty.
Yes.
And at some point around this time, the blog post got picked up by the New York Daily News, correct?
Correct.
The story started to get out there a little bit, right?
That's right, yes. It was republished or repurposed by other elements.
So the news had been disseminated, right?
Yes.
And you also worked to have the Daily News take down their internet article reflecting Ms. Daniels' allegations, correct?
I believe so.
And in connection with that effort, you working to get the story from the Daily News down, you were also acting as Ms. Daniels' attorney, right?
Yes.
Still no retainer agreement, right?
Correct.
Did you ever have an engagement letter with Ms. Daniels?
Yes.
Was that in 2016?
Yes.
Now let's focus a little bit on that 2016 engagement. You had an engagement letter for providing legal services to Ms. Daniels, right?
Yes.
And I think you described reaching a settlement, correct?
Yes.
And you've used during your testimony litigation terms like plaintiff and defendant to describe the parties to that settlement agreement, right?
Yes.
So, from your perspective, it is true, is it not, that you're providing Ms. Daniels legal services with regard to the agreement that led to the payment of $130,000?
Yes.
You talked a little bit today about the side letter to the agreement in 2016.
Yes.
Remember that?
Yes.
I think the word decoded was used, right?
Yes.
These acronyms, Peggy Peterson and David Dennison,
Yes.
that was something you had used in the past, right?
Yes.
That was your idea, right?
No, it's not my idea. It's widely used with these types of agreements.
You talked a little bit today about a December 9th, 2016 conversation with Michael Cohen, right?
Yes.
And I think you said he sounded disheartened, correct?
Yes.
And at other times, do you recall having described that conversation in terms of you left the talk in concern for his physical safety, his well-being? That's how bad he sounded?
I thought he was going to kill himself.
And the concern on that call was that he understood he wasn't going to get a position in President Trump's administration, right?
Yes.
And he had at times in conversation with you referenced potentially being President Trump's chief of staff, right?
Amongst others.
Amongst others, right. He also mentioned potentially being the Attorney General of the United States, right?
That's true.
In this call at the Wonderland warehouse, he was conveying to you that's not going to happen. And he was very, very upset about it, correct?
That's true.
Now, I would like to take a step back and talk about sort of how you've interacted with law enforcement during the course of this investigation, okay?
Fair.
It started out in 2018 with some meetings with federal prosecutors, right?
Yes,
Do you recall how many meetings?
I do.
How many?
3.
And that was in 2018, right?
Yes,
And you were asked during those meetings about your interactions with Stormy Daniels, right?
yes,
And with Karen McDougall, correct?
yes.
And in those meetings, the attorney-client privilege did not come up as much, right?
I don't know how to answer that question.
You've invoked the privilege in your testimony at this trial several times, correct?
A few times, yes.
And you've also invoked it with meetings with the district attorney that we'll talk about in a little bit, right?
Yes,
And my question is, do you recall invoking the privilege during those 3 meetings with the federal prosecutors in 2018?
yes,
And then at some point, you started to meet with the district attorney's office, right?
yes.
And that was several years later, correct? Time went by?
True.
Do you remember when the first meeting was?
Not particularly.
Does 2021 sound about right?
I don't recall.
And do you recall if the first meeting was actually remote, I think by Zoom?
Yes,
And the main person asking the questions during that meeting was Mark Pomerantz. Do you recall that?
I do.
Do you recall at some point in the meeting, Mr. Pomerantz said to you, you're obviously concerned about making statements.
Objection.
Sustained.
May we approach?
Sure.
Whereupon the following proceedings were held at sidebar.
Let me hear the objection.
Well, since I don't know what he's going to ask, it's a little hard for me to object. But I don't think he could possibly be getting into what Mark Pomerantz said to him, especially because it sounded like he was getting into Mark Pomerantz's impression of something the witness was saying, which is something prosecutors' perceptions of witnesses. Perceptions is something you precluded in other contexts, so I didn't want the question to be asked on the record.
What were you going to ask?
I was going to ask, I'm summarizing whether he recalled Mr. Pomerantz saying he was choosing his words carefully because there was extortion inferred. The reason I'm asking that question is because of the effect on the witness's state of mind in connection with his subsequent interactions with the government, because the way that meeting ended was he was instructed to get an attorney. There was then a conversation that I would like to probe where he and I don't have to use Mr. Pomerantz's name if that's offensive. I'm happy to take that out. But lawyers, a member of the district attorney's office said, we're not looking at him for extortion.
We're not looking at who?
Mr. Davidson. So there's a benefit. It's not sort of the automatic benefit that attaches to the grand jury proceedings.
So let me see if I understand this correctly. What Mr. Bove is trying to elicit, one prosecutor expressed a view that seemed to suggest that that prosecutor believed that Mr. Davidson's conduct approached extortion, but then a subsequent person said, we're not looking at you for extortion, so the internal...
The same prosecutor.
Objection sustained.
Whereupon the following proceedings were held in open court.
Objection sustained.
May I continue?
Yes.
You said something this morning along the lines of Michael Cohen could be an aggressive guy, right?
Yes.
I think that was your word, aggressive.
That's my opinion now. I think that was my word.
And you can be aggressive too, can't you?
I don't know.
You don't know?
I suppose.
What does the word extortion mean to you?
Extortion is the obtaining of property by threat of fear or force.
Compelling an action by force or coercion, how's that?
Don't know.
Is that accurate?
Sure.
And that can be a state or federal crime, right?
True.
And as you sit here today, it's your belief, is it not, that the statute of limitations on any extortion crimes has run?
Objection.
Sustained as to form. Please be more specific.
As you sit here today, is it your belief that any exposure that you have to state or federal extortion crimes is excluded by the statute of limitations?
I have no opinion.
You're an attorney and you have not thought about that prior to your testimony?
I have not.
When you were negotiating on behalf of Ms. McDougall and on behalf of Stormy Daniels, one of your concerns was on staying on the right side of the line with respect to extortion, correct?
I suppose.
I mean, that's something any attorney would naturally want to be doing in a negotiation like this, right? You were making a demand.
Well, I don't know what any attorney making a demand, that's, I suppose, fair.
But in your mind, you were concerned about avoiding creating evidence of extortion, correct?
Not particularly.
Well, one of the issues that you had to be sensitive about was not to threaten that the payment needed to be made prior to the election, correct?
I don't recall that.
You were concerned about linking those two issues, payment, election, were concerned in written communications, right?
That was not my concern.
Do you recall being asked about this issue in meetings in 2023 by the district attorney's office?
I do not.
Do you recall a meeting where you indicated that you could not recall whether the thought of election as a deadline for getting stuff done had come up?
You're asking me.
Do you remember saying that?
I remember saying I do not recall.
And it's your testimony that you, even today, you don't remember whether or not you were concerned about linking the election in these payments?
Correct.
You said on Tuesday that in the time frame 2015 to 2017, your focus was on, I think you said, media cases, right?
Somewhat.
And you also testified that you agreed with Mr. Steinglass that those cases frequently involved non-disclosure agreements. Do you remember that?
Fair.
And in terms of media practices and the types of work that you were doing in 2015 through 2017, there's nothing out of the ordinary about an NDA agreement, correct?
That's fair.
January 31st, 2018, at 1:30 UTC, from Michael to me, please tell Gina to ensure she responds the same as your statement tomorrow when she does The View, that television show. This is not a comedy show, exclamation point.
Fair.
In many different contexts, right?
Agreed.
They are enforceable, right?
True.
They're litigated sometimes, correct?
Agreed.
They are upheld often, right?
Agreed.
And so there's nothing strange to you about the fact that your practice involved NDAs in 2015 through 2017, right?
Correct.
As far as you know, that's during the time of the media lawsuits during that period?
As far as I know.
In 2016, you were pretty well versed in getting right up to the line without committing extortion, right?
I don't understand your question.
My question is that you had had several representations that involved situations where you were making demands on third parties on behalf of your clients, right?
True.
And you were asking for money and other benefits in those representations, correct?
True.
And you knew you had to be careful so as to not violate the law prohibiting extortion, right?
True.
And in 2016, you had, in fact, familiarized yourself with the law of extortion based on very specific experience, right?
No.
Isn't it a fact that in connection with events in 2012, you were investigated by state and federal authorities for committing extortion against Terry Bollea, Hulk Hogan?
That's true.
And in connection with that investigation, did you or did you not familiarize yourself with the extortion offenses that were applicable in Florida and under federal law at the time?
That's fair.
And so, getting back to my question, by 2016, you had, in fact, familiarized yourself with where that line was, right?
I had familiarized myself with the law. I'm a lawyer.
And you did everything that you could to get as close to that line as possible in these negotiations without crossing it, right?
I did everything I could to make sure that my activities were lawful.
And that included not making overt threats connected to the 2016 election, didn't it?
Threats to who?
To Michael Cohen.
No.
No, you made no threats to Michael Cohen relating to the 2016 election. Is that the answer that you give?
I made no threats to anyone.
You never linked these negotiations to the 2016 election with anyone. Is that your testimony?
That's fair.
In 2010, you represented a woman named Dawn Holland, right?
Yes.
And Dawn Holland leaked information about the treatment of Lindsay Lohan at a rehab facility, correct?
It was reported that that's what she did.
And you had connections as TMZ at the time, right?
True.
You still do, right?
No, well, perhaps.
Perhaps. You helped Ms. Holland get that information posted at TMZ, right?
No.
TMZ posted information relating to this incident with Ms. Lohan, including aspects of her confidential patient file from the facility, right?
I don't know.
It's your testimony that you don't even know what I'm talking about?
No, I'm answering your question.
So, I just asked, did TMZ post information from Ms. Lohan's confidential patient file?
I don't know.
You helped Ms. Holland get paid in connection with what I just described, didn't you?
Objection.
Overruled.
I helped Ms. Holland get paid?
Correct, that's the question.
I don't recall.
You don't recall that TMZ paid Ms. Holland $10,000 around this time?
I don't recall.
She was your client, right?
At some point, yes.
Is it your testimony that she was not your client in connection with the incident I just described?
No.
So, she was your client in connection with the incident I just described, correct?
Well, you're describing a few different incidents. I don't know what you're recalling, what you're referring to.
What I am referring to is the posting of information regarding Ms. Lohan on TMZ, and that information related to her treatment at a rehab facility.
I don't recall that.
And you don't recall Ms. Holland getting paid $10,000 by TMZ?
I don't recall that.
Do you know who Tyler Tequila is?
I do.
And in 2010, you took steps to broker a deal of a sex tape involving her, correct?
I believe so.
And you were working on that, what should I call it, engagement with a man named Kevin Black?
Yes,
And at the time, he was sort of known as a sex tape broker, is that right?
I think that's fair.
Is that how he was making his living in 2010?
I don't know.
You just said it was fair to characterize him as that, but you're not sure if that was how he was making his living?
That's correct.
Is there a distinction?
Yes.
In connection with the Tila Tequila tape, you represented the client, right?
Client.
That's my question.
I don't recall.
You don't recall representing Francis Hall?
I do not.
Do you recall that Mr. Hall, who also goes by Francis Thien, threatened Ms. Tequila that if she didn't pay him $75,000, the tape would be published?
I don't recall that.
You don't recall at the time of that transaction, you were on a 90-day bar suspension?
I don't recall that.
You know who Charlie Sheen is, right?
I do.
And you've represented some clients who you helped get paid by Charlie Sheen, right?
I've represented several clients who had claims against Charlie Sheen.
And who you extracted sums of money from Charlie Sheen on behalf of, correct?
There was no extraction.
You took steps to cause Mr. Sheen to pay, correct?
We asserted that there was tortious activity committed and valid settlements that were executed.
And one of those settlements involved a client named Karen Montgomery, right?
Yes.
And she was your client in 2011, correct?
I don't recall the year.
Do you recall that Mr. Black referred her to you?
I do recall that.
And do you recall that you entered into an engagement letter with her that required a 60% contingency fee?
I don't recall that.
Do you recall that she had recently been under the influence of methamphetamine at the time you got her to sign the engagement letter?
No, I don't recall that.
You don't recall she was barely completing sentences when you got her to sign the letter?
Objection.
Sustained.
In connection with that representation, Charlie Sheen paid $2 million, right?
I'm not going to answer that question.
Your $2 million was paid to your client, correct?
I don't recall.
Is it fair to say that your memory seems a little fuzzy around some of these issues?
I've had over 1,500 clients in my career. You're asking me about events that took place many, many years ago.
A $2 million payment is a typical payout for you on one of these cases, so much so that you don't remember it. Is that your testimony?
I don't remember a settlement from 13 years ago.
What about Capri Anderson? Do you remember her?
I do remember her.
And do you remember extracting another settlement from Mr. Sheen while representing her?
Again, it was no extraction.
You got Mr. Sheen to pay, correct?
Assuming arguendo that he did pay and there was a settlement agreement, that settlement would be confidential and I would not discuss it here.
Look, we're both lawyers. I'm not here to play lawyer games with you. I'm just here to ask questions and get straight answers.
Objection.
Sustained.
I'm not asking you to assume anything. I'm asking what you remember. All right, can you answer?
In answer to what?
I'm not asking you to assume anything. I'm just asking for truthful answers, okay?
You're getting truthful answers, sir.
So when I ask a question, I'm not asking you to assume arguendo, all right? I'm just asking for what you remember.
I'm not going to discuss confidential matters.
Well, that's a different answer, isn't it? Now you're invoking the privilege.
No, I'm not invoking the privilege. And if you're not here to play legal games, then don't say extract.
Do you remember Mr. Sheen paying your client, Capri Anderson?
I'm not going to discuss that.
Judge, I ask that the witness be instructed to answer the question.
Please approach.
Whereupon the following proceedings were held at sidebar.
So this is a sensitive area here. I think we need to establish first that he's definitely not asserting any kind of privilege.
Okay.
Once he says he's not asserting privilege, you can ask him the question again. If he refuses to answer, you can ask me for help.
Yes, thank you.
Whereupon the following proceedings were held in open court.
So I want to focus on your representation of Capri Anderson, okay?
Fair.
My question is, was there a settlement between Ms. Anderson and Mr. Sheen in connection with that representation?
I'm not going to answer that.
When you say that, you're not invoking a privilege, correct?
I'm not going to answer that question based on privilege and confidentiality.
And what privilege are you invoking?
The attorney-client privilege.
So what I'm asking for is details about communications between you and your client and a third party, Mr. Sheen, and maybe his representatives, maybe not. Do you understand my point?
No.
Is it your position that those types of communications are privileged in an adversarial negotiation context?
Yes.
Your Honor, I ask that the witness be instructed to answer the question.
You can ask him another question. He's asserting privilege.
Let's focus on 2012, okay?
Yes.
Do you recall that Gawker ran a clip from a purported sex tape regarding Hulk Hogan that year?
I do.
Do you recall that prior to that post, still images from one of the images appeared on The Dirty, right?
Yes.
That same website that in 2011 had the post about Ms. Daniels' allegations, correct?
Yes.
And you used your connections at The Dirty to help get the Hulk Hogan stills posted, right?
No.
You had nothing to do with that?
Nothing to do with it.
And at some point in 2012, you reached out to Hulk Hogan's representatives, right?
Yes.
And you indicated to them that the Gawker post was a, quote, shot across the bow, right?
I don't recall that.
Do you recall that during the negotiations of Mr. Hogan's representatives, you said, I'm an expert at doing this type of thing?
I don't recall that.
Do you recall discussing this issue, the conversations that you had with Mr. Hogan's representatives with Michael Cohen?
I do not.
Mr. Bernick, if we could bring up People's Exhibit 255 in evidence and go to, this can be for everybody. If you go to the page of Bates number ending 214573, if we could zoom in, please, on row 53, I think it is. Now, I think you said this morning these are messages between you and Mr. Cohen, right?
Yes.
So, does this refresh your recollection that in January 2018, you were communicating with Mr. Hogan about your prior dispute with Hulk Hogan and communication regarding that?
I was communicating with Michael Cohen about Hulk Hogan.
Right, you were communicating with Michael Cohen about Hulk Hogan?
Yes.
So this communication refreshes you?
Yes.
We can take that down? I want to go back to focusing on October 2012, and you had reached out to Hulk Hogan's representatives regarding this Gawker post and the sex tapes, right?
Yes.
At that time, you were acting as an attorney, correct?
Yes.
You had clients, right?
Yes.
Who possessed the tapes, right?
Yes.
And you said to Hulk Hogan's representatives, did you not? We got a lot of people, they get caught on tape. They're not all celebrities. We have family men that are gay, and they want to keep their gay identity undercover. So we approach them too. Do you remember saying that?
I do not.
Do you remember demanding $1 million?
I do not.
You made a monetary demand to Hulk Hogan's representatives in order to not publish these tapes, correct?
No.
Did you ask for money?
There was a monetary demand made.
Was it for purchase, so that Hulk Hogan could purchase the tapes, the right to the tapes?
Yes.
Do you recall that the National Enquirer published information relating to these tapes in 2015?
No.
This is just for parties and the witness and the court. If we can take a look at Defense Exhibit F27, if we can go to page 2, please. Take a look at that and let me know when you are done.
Okay.
Did you have a chance to take a look?
Yes.
Does this refresh your recollection that the National Enquirer ran stories about the tapes in the summer of 2015?
Yes.
Did they?
Yes.
And do you recall that Dylan Howard had a byline on one of those articles?
I do not.
Can you take a look at Defense F27, please, and see if that refreshes your recollection?
Yes.
So Dylan Howard did, in fact, have a byline on articles relating to the Hulk Hogan tapes, right?
In this article, yes.
And that's because you referred this information to him, correct?
No, that's not.
It is just happenstance?
I don't know.
You don't know?
No, I don't know if it's happenstance.
Did you or did you not provide information to Dylan Howard so he could break the story about the content of one of the tapes?
No, I did not.
Did you cause information to be disclosed to Dylan Howard so he could publish an article in the National Enquirer about the content of one of these tapes?
I did not.
And there was an FBI investigation relating to this, correct?
Yes.
You practiced criminal law in the beginning of your career?
True.
State and federal?
Yes.
So you understand, do you not, that the FBI needs enough information to actually predicate a criminal investigation?
Objection.
Sustained. The FBI ran a sting operation targeting your meetings with Hulk Hogan's representatives, correct?
They had an investigation, yes.
When I say sting operation, you know what I mean.
Not technically.
They set up a meeting where someone was recording what you were saying in connection with the negotiations?
Yes.
That was at a hotel, right?
Yes.
And the FBI was sitting a couple of doors down, correct?
I don't know. They were in close proximity.
They were in close proximity monitoring the situation, right?
I presume so.
You know that this was also investigated by local authorities, correct?
Yes.
And that there was a report issued relating to the two investigations and the local authorities?
There was a report issued.
Do you recall that?
No response.
Mr. Burnick, this is for the court and the parties and the witness. If you can take a look at Defense F-35, please. I'm going to hand you a copy so you could flip through. Have you had a chance to look at that?
It's 31 pages. I have looked at that.
My question is, does that refresh your recollection that the Tampa Police Department issued a report relating to the investigation that we have been talking about?
I didn't, yes.
Do you recall that in that report, the Tampa Police Department indicated that the operation...
Objection.
Sustained.
You can put the document to the side. Thank you. The Tampa Police Department referenced concerns about extortion in connection with this investigation, correct?
Objection.
I will allow it. You can answer it.
They conducted an investigation, yes.
An investigation relating to extortion, right?
I believe so.
And there were conclusions about concerns relating to extortion, just yes or no?
Objection.
Sustained.
And you were not ultimately charged, right?
True.
But that experience gave you familiarity with extortion law, correct?
Perhaps I don't know.
Do you know who Gabriel Rueda is?
Yes.
And he had a dispute with CBS and Manny Pacquiao?
Dispute is loosely used.
He felt that he was owed a finder's fee relating to one Pacquiao's fights, right?
Yes.
A big fight?
Yes.
With Floyd Mayweather?
Yes.
You tried to convince Mr. Rueda to settle that dispute, right?
I offered him a settlement.
He felt he was owed millions and millions and millions of dollars, right?
$100 million.
$100 million?
Yes.
You offered him $50,000, correct?
No.
You made a settlement offer to him, right?
Yes.
And it involved a sum of money that was much less than $100 million?
It was far less than $100 million.
On June 25th, 2015, you told Mr. Rueda he was dealing with powerful people who did not care if Rueda got hurt, right?
I never ever said that. I did not say that.
You also threatened he would not be able to find work in California if he did not accept your settlement, correct?
That's false.
Now, I want to get back to the clients that you talked about in this case.
Fair.
Let's start with Ms. McDougall. I think you said that your attorney-client relationship started in June 2016, right?
I believe so.
By that time, there was someone else leaking information publicly about this alleged relationship between Ms. McDougall and President Trump, right?
I don't know about that, about leaking. Ms. McDougall had a friend, and when your client was ascending in the polls, one of Ms. McDougall's former friends attempted to publicize Ms. McDougall's interactions with your client.
That is Gary Stevens, right?
I don't know.
Do you remember telling the district attorney's office that Ms. McDougall had a friend who was trying to publish a story without her consent?
Telling whom?
That there was a friend of Ms. McDougall's who was trying to publish a story without her consent?
Who did I say that to?
The district attorney's office.
Yes.
At the time, you said that you knew who you were talking about, right?
I don't know if I ever heard that name Stevens.
I think you testified on direct that your fee in connection with the representation of Ms. McDougall is 45%. Is that right?
I believe so.
You testified on direct that Jay Gradina had introduced you to Ms. McDougall. Is that right?
No.
You knew Ms. McDougall for a while, but Jay came to you about this particular representation?
Yes.
Jay Gradina had been a client of yours?
Yes.
Jay has a brother, correct?
Yes.
Named James?
Yes.
If I call him James, you know who I'm talking about?
I do.
So James was married to McDougall, correct?
That's my understanding.
There was sort of a referral chain for how you became in 2016?
Yes.
And you mentioned somebody named John Crawford. Do you remember that?
Yes.
I think you said he provided security at a meeting or two.
He was, I think, a retired police officer from Phoenix.
He also owned some UPS stores in Phoenix.
True, that's my understanding that he owned UPS stores.
Mr. Burnick, can we please take a look at People's 279 in evidence? This can be for everybody. Can we zoom in on the email, please? So I think we looked at this on Tuesday. This is you submitting a proposed engagement letter to Ms. McDougall, right?
Yes.
Do you see the BCC line?
Yes.
That JG, is that Jay Gradina?
Yes.
Why did you include him on the BCC line?
I don't know.
And this document was never executed, right?
I don't know if there was a retainer agreement that was executed.
Do you know if it's the one that is attached to the email or a different letter?
I don't know.
You said you got a subpoena at some point from the district attorney's office?
Yes.
And did you search your files for the signed version of this letter?
I believe so.
And is it fair to say you did not find one?
I provided whatever was located.
My point. There was nothing wrong in terms of your relationship with Ms. McDougall that it wasn't signed?
It was my recollection that I had a fully executed, a retention agreement with Ms. McDougall.
Mr. Burnick, can we take a look at paragraph 4.2 in the subparagraphs? I am focused on paragraph 4.2, where it seems to indicate that the fee contemplated in this letter was 35%. Do you see that?
Yes.
Do you recall a subsequent negotiation that increased your fee to 45%?
I don't recall that conversation.
And now the difference between these two numbers, 35 and 45%, on the $150,000 payment is 10%, about 15 grand, right?
Yes.
And some of the fee that you were paid was split, correct?
No.
So is it your testimony that Jay Gradina made nothing in connection with the payment of the $150,000?
He was compensated.
Out of the legal fees, correct?
No.
What about John Crawford?
He was compensated as well.
He was compensated out of your fee, yes or no?
No.
Do you know that the California ethics rules prohibit non-attorneys from being paid out of legal fees, right?
Correct.
You have been disciplined on that basis, correct?
No.
So we'll go back to the first page of the email. Can you see it? That is dated June 15th, 2016.
Yes.
This was sent right around the time that you went to Phoenix to meet with Ms. McDougall, Mr. Gradina, and Mr. Crawford, correct?
Yes.
Before the meeting, you had already talked to Dylan Howard, right?
I don't recall.
Mr. Burnick, if we can take a look at People's 176.
I would like to go to the page with the text messages on June 7th, 2016. Zoom in on the rows beginning 111.
Have you had a chance to take a look?
Yes.
These are messages dated June 7th, 2016 between you and Dylan Howard?
Yes.
In these messages, you indicated, I have a blockbuster Trump story. Do you see that on the top?
Yes.
You were reaching out to Dylan Howard to tell him about Ms. McDougall's allegations, correct?
Not necessarily.
You were reaching out to Mr. Howard to get him interested in the potential story, right?
I think that's fair.
And it would make you look better when you went to Phoenix to be able to say, I have already got the National Enquirer interested in this, correct?
I don't know about that.
It did not help you gain trust with the client to be able to say that you had already generated interest in the potential story. Is that your testimony?
No, that's not my testimony.
So it was helpful to you to be able to say to Karen McDougall and Jay Gradina in mid-June of 2016, you had already communicated with the National Enquirer, right?
Maybe or maybe not, perhaps.
And this is one of the ways your relationship with Dylan Howard benefited your law practice, right?
I don't see that the two are related.
You testified on Tuesday about a meeting that you had with Ms. McDougall in Los Angeles. Do you remember that?
Yes.
I think you showed some text messages. We eventually got to the point where you remembered that the meeting was on June 20th, 2016.
I believe so.
Mr. Howard traveled to Los Angeles for the meeting, right?
Yes.
At the meeting was also Ms. McDougall?
Yes.
Jay Gradina?
Yes.
Mr. Crawford, correct?
Yes.
And the purpose of that meeting was for Dylan Howard to sort of vet Ms. McDougall's story, right?
Yes.
You knew he was going to take the information and his observations and report back to AMI's leadership, right?
To David Pecker.
To Mr. Pecker, the top of the totem pole of AMI?
Yes.
You were informed, were you not, the next day AMI was not interested?
Yes, I was informed at that time they were not interested.
I think we saw a text message where Mr. Howard wrote to you that AMI was immovable. Do you remember that?
Vaguely.
And the issue was, one of them, that AMI felt McDougall had not provided enough corroborating information, right?
Yes.
Meaning evidence to back up her story, correct?
Yes.
And that is why shortly thereafter you texted Mr. Howard, you said Ms. McDougall found her BlackBerry, right?
But he asked her to locate additional documents, and so, yes.
It was in response to that request you wrote to Mr. Howard shortly after the meeting. She found her BlackBerry?
Correct.
There were efforts made to take information off that BlackBerry, right?
I don't know about that.
The BlackBerry ended up not moving the needle for AMI in terms of corroboration, correct?
I don't know.
There was no conversation that you were a party to where AMI said, oh great, now that we know the BlackBerry exists, let's move forward with the story, right?
I never had that conversation.
In this same month, June 2016, things had broken down enough that you sent a message to Mr. Howard indicating you were drafting a declination letter. Do you remember that?
I don't recall that.
If we can take a look at Government Exhibit 176. Page 3, zoom in on 11:15 and 56.
Yes, okay.
Does this refresh your recollection that you told Mr. Howard in June 2016 that you were drafting a declination letter?
Yes.
You were, correct?
I don't recall. I don't recall.
At this point, Ms. McDougall started to negotiate with other companies, right?
I don't know.
Is this a good time to stop?
Yes, Judge.
Jurors, we'll start back up at 2:15. Do not discuss the case among yourselves or with anyone else. Please keep an open mind as to the defendant's guilt or innocence. Please do not form or express an opinion as to the defendant's guilt or innocence. Enjoy your lunch.
Jury leaving courtroom.
Please be seated. Thank you, sir. You may step down.
Witness leaving courtroom.
Mr. Bove, I am not rushing you at all. I want to get a sense of how much more you have.
I will make some adjustments at the lunch break. I expect it's under an hour.
Thank you. Enjoy your lunch.
Whereupon the court took a luncheon recess.
Good afternoon. Is there anything that we need to discuss before we bring the witness out?
There is one issue, if I could have a few minutes to discuss. I wanted to raise an issue about the gag order and just some clarification before we start. If I could hand up some articles here and give a copy. Thank you. Your Honor, I just handed up a stack of newspaper articles by legal commentators and others. People like the first one is entitled, Trump's New York Prosecution is a Bogus Case by Bogus Prosecutors. And these articles are by a number of legal commentators, including Jonathan Turley and Andrew McCarthy. These articles are all articles which President Trump would like to post on his Truth, but they all discuss this case. They discuss witnesses who have testified. They discuss what the aspects of the case are. They're very critical of this case. They're important for his election campaign. They're talking about the kinds of issues that he has been raising, but he has some concerns because they do mention witnesses. They mention the prosecutors in this case by name. We think they are perfectly fine, but we think there is some ambiguity in the gag order. So we're asking for your honor to take a look at them so that he knows he is not violating the gag order when he posts this.
People?
Judge, first of all, we've just been handed this stack. If anything, we need to go through them. But it seems odd that they're asking the court for sort of an advanced ruling on these kinds of things. I think the gag order is very specific. So I guess my first request would be to have some time to look at it. We don't want to be in this position either. They're talking about witnesses in the case, people that the defendant is not supposed to be talking about based on the gag order. I understand and fully respect that there is a political campaign going on. There is also a criminal case going on in this courtroom. That's what the order is seeking to protect. I think we need to really be careful with this situation.
I appreciate what you are bringing to my attention, Ms. Necheles. I'm not going to give advanced rulings. I'm not going to be in a position of looking at posts and determining in advance whether you should or should not post these on Truth Social as part of your official campaign website. There is no ambiguity in the order. The appellate division has already weighed in on that. We'll see where it goes from there. At this point, this court and the higher court have found there is nothing wrong with the gag order. I think the best advice you can give your client is to do without. Steer clear.
Your Honor, I hear what you are saying. I heard what the appellate court has ruled. I think they're ruling in the abstract. I believe their ambiguity.
I am not going to argue with you. If you have an issue, take it up to the appellate division. Take it up to the Court of Appeals. I am not revisiting my order. I am not going to.
What we're seeking a clarification on when the witnesses have testified, or when there is an analysis of the case and it mentions witnesses, or it mentions that the prosecutors made certain arguments in this court, or the prosecutors were appointed by a certain justice. These are people who are analyzing the case, and that is what talking about it being a political President Trump wants to be arguing at its core. And I, frankly, don't know whether that violates the gag order.
I am not going to give you an advanced ruling on this. Let's get the witness. I think when in doubt, steer clear. That's all I can say.
Witness entering courtroom.
Good afternoon, sir. Let's get the jury.
Do all parties stipulate that all jurors are present and properly seated?
Yes.
Yes.
Good afternoon, jurors.
May I?
Yes.
Mr. Davidson, I would like to talk a little bit more about the 2011 blog post. You have testified a little bit about a woman named Gina Rodriguez, right?
Yes.
Who you said was Stormy Daniels' manager for a long period of time, right?
Yes.
Perhaps on and off at times?
I'm not sure.
But in 2011, Gina Rodriguez was Stormy Daniels' manager, correct?
That's my understanding.
And you referenced at times that Gina Rodriguez had a boyfriend that was involved in some of these things, right?
Yes.
And his name was Anthony Kotzev?
Yes.
Am I pronouncing that right?
Yes.
Isn't it a fact that Mr. Kotzev actually wrote the blog post that was put on the Dirty in 2011
I don't know. He was an employee of the Dirty.
You don't recall saying that to the government?
I recall that.
The Dirty was owned in part by James Gardina, right?
I don't think so.
He worked there, correct?
James Gardina.
Yes.
I don't know.
And James Gardina is Karen McDougall's ex-husband, right?
Yes.
James Gardina and Jay Gardina are brothers, right?
Yes.
And Jay Gardina brokered your connection to Ms. McDougall in that representation?
Yes.
And is also connected to Gina Rodriguez, right?
Jay?
Jay, right?
I don't think so.
So it's your testimony that Jay Gardina has never worked with Gina Rodriguez?
I don't know.
So let's focus then on that 2011 representation of Stormy Daniels.
Yes.
The reason that you were able to get that blog post taken down is because Gina Rodriguez's boyfriend had written it, correct?
I don't know who wrote it, but one don't think they were dating at the time.
It's your testimony that Gina Rodriguez was not involved with Anthony Kotzev in 2011?
I don't know if she was. I don't think she would have needed me. She would have called her boyfriend.
You used this network of connections to get the blog post taken down, correct?
In addition to the cease and desist.
You practiced law for a long time, right?
Yes.
You won cases in court?
Yes.
This cease and desist letter was not one of your greatest litigation victories?
It was a form letter.
It was a form letter created in that context because you had connections to the Dirty?
I certainly followed the cease and desist up with a phone call.
Isn't it a fact that the reason that Ms. Daniels and Ms. Rodriguez wanted that blog post taken down, they were trying to negotiate a better deal with In Touch magazine?
That's a fact that I learned later, yes.
They were using you in connection with them?
I don't understand your question. They were using my efforts to create an exclusive opportunity with a different publication.
And that exclusive opportunity was more valuable to Ms. Daniels, right?
Yes.
They were using you to make more money, right?
Yes.
Now, you testified about some public statements that Ms. Daniels made in January 2018, correct?
Yes.
At around this time, Larry Flint offered to indemnify Stormy Daniels in connection with any litigation arising out of the settlement agreement, correct?
There were others. I was not involved. It's my understanding there were other terms as well.
But one of the terms, if there was going to be litigation relating to the settlement agreement that you helped to negotiate, he would indemnify her.
Yes.
Indemnify means he would be paying her legal bills, correct?
True.
You testified this morning about some stress that you perceived Ms. Daniels to be going through in January 2018 relating to this agreement, right?
Yes.
In fact, she had this opportunity to have her legal fees paid if she wanted to fight the agreement, right?
Yes, but you can. Even if someone is going to pay your legal bills, it's still an obstruction in your life. Yes.
From your perspective, this settlement agreement was a valid legal document, right?
Yes.
You had negotiated it, right?
True.
It had legal terms, right?
Yes.
And it was certainly consistent with your beliefs about your ethical obligations, right?
Yes.
You didn't do anything wrong in connection with that agreement, right?
I don't believe so.
Want to talk a little bit about your relationship with Michael Cohen?
Yes.
You continued to work with him after the Stormy Daniels settlement, right?
Yes.
On other matters?
Not with him. But I continued to certainly speak with him, correspond with him. He was opposing counsel on another matter.
And he sent you some business, right?
He sent me work.
He sent you a client?
He sent me a non-paying client.
So it's not as if the experience with him was so horrific that you ceased interacting with him, correct?
No, our relationship changed over time.
And in 2018, had you heard the name Summer Zervos?
I believe so.
Did you discuss Summer Zervos with Mr. Cohen?
I can't recall.
What about Justin Best?
Yes.
That's the client he was talking about, right?
Yes.
So this is a situation where Mr. Cohen referred you a client?
Yes.
And you accepted that, right?
Yes.
Because you were continuing to work together, correct?
No.
You were continuing to interact professionally, right?
That's fair.
And you also had a client named Shara Betchard?
I had a client named Shara Bashard.
She retained you in about November 2017, correct?
I'm not sure of the date.
Late 2017, give or take?
I would have to look. That doesn't strike me as wrong.
And she had made allegations about a sexual relationship with a man named Elliot Broidy?
I think that's been publicly reported.
Just so I understand the privilege analysis, if something from your perspective, if something is publicly reported, you are comfortable reporting privileged conversations about it?
No.
You are aware of the public reports about Ms. Beshard's allegations?
I was aware of the public reporting of her allegations.
She was your client?
Yes.
Mr. Cohen represented Mr. Broidy?
Ultimately.
There was a settlement agreement, correct?
True.
This settlement agreement was legal work for you, right?
I don't understand the question.
You were practicing law when you negotiated the agreement?
True.
So was Mr. Cohen, as far you could tell?
True.
It resolved in a contract?
True.
It probably had terms like the ones you negotiated on behalf of Ms. Daniels, correct?
I would imagine.
Maybe with one notable exception that the dollar figure was a lot higher, right?
I don't recall.
You don't recall that the settlement was for $1.6 million to be paid in installments?
I don't recall.
As you sit here today, you don't recall events from 2018? Is that your testimony?
I don't recall specific dollar amounts in a settlement agreement from 6 some odd years ago.
Even after this settlement between Ms. Betchard and Mr. Broidy, you continued to communicate with Mr. Cohen, right?
I believe so.
Well, I mean, so we looked at the text messages, right?
Yes.
You remember this morning, correct?
Yes, I remember this morning.
The text messages from January 2018, right?
Yes.
They continued in February 2018, right?
Yes.
And March 2018, correct?
Yes.
In the context of those discussions, did you ever talk to Mr. Cohen about Stormy Daniels having settler's remorse?
I may have.
And do you recall in that conversation also using the word leverage?
No.
Is leverage a word that you used in conversations with Mr. Cohen?
I may have.
And you did, in fact, in March of 2018, correct?
Use the word leverage.
In a conversation with Michael Cohen about Stormy Daniels?
I don't know.
During meetings with the district attorney's office, they asked you questions about whether Mr. Cohen had ever recorded your conversations, correct?
I don't recall if it was what agencies. It came up at some point in an interview.
And I think you said, did you not? Yeah, I was under the impression that he did record some of these talks.
Certainly I recall a few conversations when I was speaking with Mr. Cohen when his conversations were odd, and that led me to believe that I was being recorded.
I think you said the reason they seemed odd to you, he was talking in a linear fashion?
Yes, because ordinarily he was sort of all over the place. In these particular calls, it was a very structured conversation, which really wasn't his personality.
Less pants on fire, more straightforward?
Maybe a little bit more self-serving.
Do you recall saying to Michael Cohen on March 7th, 2018, sometimes people get settler's remorse, and other times people think that, hey, I need to resolve this case before a date certain because this is when I have the most?
No.
If we can bring up for the parties, the court, and the witness, Defense Exhibit F-15AT. There is also a set of headphones on the bench. I think the way this works, there is a dial in the middle. I'm told if you put the volume up above 2, there's a risk of catastrophic damage to your ears. Thank you. So we're going to play Defense Exhibit F-158A over the headphones. I'm going to ask you to listen to see if it refreshes your recollection about whether you said what I just said.
Are you playing it?
I think it might help. That's the receiver, whatever you call this. It should come on. Any luck?
If you could restart it.
Whereupon witness was given headphones to listen to audio recording.
Restart it, please.
Whereupon audio recording was played for the witness and the court only.
All right, dude. Well,
this is hypothetically speaking. This is, sometimes people get settler's remorse. And other times people think that, hey, I need to resolve this case before a date certain because this is when I have the most.
you know what bothers me the most?
No, hold on 1 second. Hold on. Hypothetically, people think, hey, I need to settle this case, the most, but before this date certain because after that date, I have no more leverage. Well, if the things don't turn out the way that you thought they were going to turn out, and now you realize you have a lot more leverage, so you try to settle it twice.
Right.
Or someone like Larry Flynn or somebody else comes in and says, I'll give you $1 million, but first you got to get out of the agreement. Hypothetically speaking.
Right.
Is this the beginning?
Play it one more time.
Start it from the beginning.
Whereupon the witness and the court listened to audio recording.
Stop it. So, Mr. Davidson, it continues. We're going to go back to it. That was your voice?
Yes.
Does that refresh your recollection that you said to Mr. Cohen, sometimes people get settler's remorse, and other times people think, hey, I need to resolve this case before a date certain because this is when I have the most. What you just listened to, does it refresh your recollection that you said that?
Yes.
You were talking about Stormy Daniels here, correct?
Probably.
Just yes or no. Were you talking about Stormy Daniels with Michael Cohen on March 7th, 2018?
Objection.
Overruled, if you could answer yes or no.
It certainly appears to be, yes.
And do you see the reference to before a date certain?
Yes.
That's something you said to Mr. Cohen in March 2018, right?
Yes.
And that is a comment that you were attributing in substance to Ms. Daniels, correct?
Not necessarily.
I am asking you, what was going on in your head at the time?
What time?
When you had said these things, this is 2018, yes?
I don't know what time you are referring to.
When you said what is written on the page, were you referring in substance to something that Ms. Daniels had conveyed to you?
I don't believe so.
And when you used, do you see where it says hypothetically speaking?
Yes.
That was a code, right?
No.
Because you were using the word hypothetical. So you could sit in a chair like this and say, I'm not sure if I was talking about Stormy Daniels.
No.
Do you recall saying during the same conversation with Mr. Cohen, well, if things don't turn out the way that you thought they were going to turn out, and now you're realizing you have a lot more leverage, you tried to settle it twice?
Can I see the transcript?
Yes.
Thank you.
So we're going to bring up Defense Exhibit F15AT again. I want to do whatever I can to refresh your recollection. Is the transcript sufficient?
That's fine, thanks.
Does looking at the transcript refresh your recollection that you had said that to Mr. Cohen in March of 2018?
Yes.
And you used the word leverage, correct?
Yes.
And that was Ms. Daniels' goal, was it not, to create leverage over President Trump?
No.
Do you recall saying during that same conversation, if someone like Larry Flynt or someone else comes in and says, I will give you $1 million, but first you got to get out of the agreement, hypothetically speaking, do you recall saying that to Mr. Cohen on March 7th, 2018?
Yes.
That was a reference to Larry Flynt?
Yes.
Who made the offer to Ms. Daniels, right?
Yes.
Does that refresh your recollection that this entire conversation is about Ms. Daniels?
Yes, but I think you are grossly mistaken about it.
There is no question pending.
Objection. I would ask that the witness be allowed to answer.
You can go ahead and answer the question.
I think you are grossly mistaken about the date. This is years after the settlement, and this is talking about a potential breach, where Larry Flynt had offered to give Ms. Daniels $1 million, plus indemnify her from any legal costs, because she wanted to get out of the settlement agreement that she had entered into 2 years before.
Which is shorthand for settler's remorse, correct? Which was your phrase?
That's true.
Now, at some point, Ms. Daniels got new counsel, right?
Yes.
Michael Avenatti?
True.
And Gina Rodriguez continued to work with Ms. Daniels in that time frame, right?
For a period.
So for some period of time, Ms. Daniels' legal representation was Mr. Avenatti, assisted in that agent capacity that we talked about by Gina Rodriguez?
For some period of time.
And certainly that was the case in, let's say, the second third of 2018?
I don't know. It's my recollection that Miss Rodriguez's tenure did not last for very long once Mr. Avenatti came in.
Do you recall saying to Michael Cohen, Avenatti has really driven a wedge, a serious wedge between Stormy and Gina. Avenatti is leaning on Gina saying, basically, we know we're lying. We know we're full of shit in the media. We know that she was never threatened in Las Vegas. We know all these things. Do you recall saying that to Mr. Cohen?
That sounds like something I recall.
Yes or no, do you recall saying that to Mr. Cohen?
I don't doubt I said that. I don't have a specific recollection of that quote.
That's fair. We'll listen it. You can put the headphones back on, please. I'm going to ask Mr. Bernick to play defense, which corresponds to the transcript.
Whereupon the witness using the headphones played the audio recording.
Avenatti's lying his ass off, as you know, and I know, and Gina knows. And Stormy knows. And Stormy's lying. Right?
Are you speaking with Gina?
On occasion. We went a long time without speaking. Gina brought Stormy to Avenatti. And we went a long time without speaking. And now that Avenatti has really driven a wedge, a serious wedge, in between Stormy and Gina, Avenatti is leaning on Gina saying, basically, we know we're lying. We know we're full of shit in the media. We know that she was never threatened in Las Vegas. We know all these things.
Does that refresh your recollection that you did say those things to Michael Cohen on April 4th of 2018?
Yes.
That was your voice on Defense Exhibit F17C?
Yes.
In that same time frame, April 2018, you did some public interviews, right?
Yes.
I believe CNN?
I believe so.
You talked with Michael Cohen about the questions and answers during the interviews, right?
Can you rephrase your question, please?
Did you speak to Michael Cohen about your CNN interviews?
Yes.
Do you recall saying this to Michael Cohen about one of the interviews? The $130,000, was there ever any indication that the money was coming from? Answer is no. Was there ever any indication that Michael Cohen needed authority from Donald Trump before he made that payment? And I said, no, it was never discussed. Do you recall saying that to Michael Cohen?
Vaguely.
Go back to the headphones.
It's fine.
I appreciate it. Let me state it for the record. We're now going to play Defense FI 7.
With the corresponding transcript, which is -18.
Whereupon audio recording was played for the witness and court only.
The $130,000. Was there ever any indication that the money was coming from him? And I said no. They said, was there ever any indication that Michael Cohen needed authority from Donald Trump before he made that payment? And I said, no, it was never discussed. They said, did you ever ask Michael Cohen what conversations he had with Donald Trump about this payment? I said, no. And why would an attorney ever ask opposing counsel what kind of conversations they had with their client? Like, that's between them. To the extent that it happened or didn't happen, I have no idea. But as far as my conversations with Michael Cohen go, it was solely about negotiating a deal and completing a deal that two consenting adults or that my client wanted and his entity wanted. That's it. What else did they ask? That's pretty much it. I think it's going to air later today.
Oh, yours is going to?
Yeah. Okay. And I think, look, it's the truth, Michael. You know that. But I think that you and I both want the truth out there.
I do, for both of us.
I think the wrong transcript is up.
Please stop that there. Does that refresh your recollection that you said to Mr. Cohen, was there ever any indication that Michael Cohen needed authority from Donald Trump before he made that payment? And I said, no, it was never discussed. You said that, right?
That's true.
You also, in that conversation with Michael Cohen, said, and why would an attorney have ever asked opposing counsel what kind of conversations they had with their client? You said that, right?
Yes.
And you believe that, right?
Yes.
And the same way you invoked the privilege here, correct?
Yes.
And Michael Cohen didn't breach any privilege talking to you about the Stormy Daniels negotiations, did he?
Not that I am aware of.
And in that conversation later, did you or did you not say, look, it's the truth, Michael, you know that, but I think that you and I both want the truth out there?
Yes.
You said that, right?
Yes.
In this time frame, around the time of the CNN interview, April 2018, do you recall speaking with Michael Cohen about Gina Rodriguez and Mr. Kotsev?
No.
Do you recall saying to Mr. Cohen, Gina Rodriguez's boyfriend goes out in the media and tells the story that Stormy Daniels, in the weeks prior to the election, was basically yelling and screaming and calling me a pussy? Do you recall saying that to Mr. Cohen?
I don't.
So if we could bring up the transcript on the screen, please, Defense Exhibit F-17ET, and play the corresponding audio, Defense F-17E, please.
Whereupon the witness using the headphones played audio.
I just didn't want you to get caught off guard, and I wanted to let you know what was going on behind the scenes. And I would not be the least bit surprised if, I wouldn't be the least bit surprised if you see in the next couple days that Gina Rodriguez's boyfriend goes out in the media and tells a story that Stormy Daniels, in the weeks prior to the election, was, basically yelling and screaming and calling me a pussy.
Can I ask you a question? Right.
No, hold on 1 second. I wouldn't be the least bit surprised if he comes out and says, you know what, Stormy Daniels, she wanted this money more than you can ever imagine. I remember hearing her on the phone saying, "You fucking Keith Davidson, you better settle this goddamn story, because if he loses this election, and he's going to lose, if he loses this election, we lose all fucking leverage. This case is worth zero, and if that happens, I'm going to sue you because you lost this opportunity. So settle this fucking case." That's a far cry from being, bullied and pushed into settling a case.
Right.
Does that refresh your recollection that you said that to Michael Cohen around the time of the CNN interview?
I don't know what date the CNN interview was, but I said it on April 4th.
Do you recall also saying to Mr. Cohen, "I wouldn't be the least bit surprised if he comes out and says, 'You know what, Stormy Daniels? She wanted this money more than you could ever imagine. I remember hearing her on the phone saying, "You fucking Keith Davidson, you better settle this goddamn story, because if he loses this election," and he is going to lose, "if he loses this election, we all lose all fucking leverage. This case is worth zero." Do you recall saying that to Mr. Cohen?
I do.
Do you remember at the beginning of my questions when I asked about whether the election was used as a leverage point in connection with the Stormy Daniels negotiations?
I do.
I would like you to take a look at the agreement that you negotiated on behalf of Ms. Daniels. People's 26 in evidence. This could be for everyone. From your perspective, this is a legal document?
Yes.
The type of settlement agreement that you've negotiated many times over the course of your career, correct?
That's fair.
You've negotiated non-disclosure provisions?
Yes.
And you did that here on behalf of Stormy Daniels as an attorney, correct?
Yes.
There isn't fake language designed to hide something, right?
I don't know. It's a very long document. It's not fake language.
It has copyright provisions, right?
Transfer of copyright.
I don't know what that means, honestly. It's a serious legal part of this agreement, right?
Yes.
So if we can take a look at Bates ending 021, this is the copyright transfer, right?
Yes.
You have used similar documents like this before, right?
Yes.
In the course of your practice on behalf of other clients, right?
Yes.
You did that here because you were trying to help Ms. Daniels negotiate an agreement, right?
This was the agreement, yes.
And these are valid terms from your perspective, right?
Yes.
As is the rest of the agreement?
I believe so.
If we could look at the Bates ending 020, please. This is the signature page, right?
Yes.
And can we zoom in on the signature, please? And I think you said Mr. Cohen signed at the bottom, right?
Yes.
There is an Esquire by his name?
Yes.
From your perspective, he signed this agreement as an attorney, correct?
Yes.
There is a blank for David Dennison?
Yes.
You don't know one way or the other what happened with this agreement after you sent it to Michael Cohen?
I do not.
It's unsigned here, correct?
True.
If we can take that down and look at Bates 017, this is another signature page, correct?
What was the last page, page 15?
We'll back up one page, please.
It's just a continuation of the signature block.
Look at 017016. This is the end part of the main agreement?
Yes.
Now go back to the signature page, 017. It's blank here as well in the DD space, right?
Yes.
That's the initials for David Dennison?
Yes.
This is a practice that you used before, using initials in the main body of the agreement?
It's common.
You even used it with Hulk Hogan, right?
I believe so.
This is unsigned, correct?
Yes.
You don't know one way or the other whether it was signed by DD?
By DD, yes.
I have nothing. Any redirect?
Can I have 5 minutes?
Are you asking for 5 minutes?
Yes.
All right, jurors, let's take 5 minutes.
Jury leaving courtroom.
You may be seated. Thank you, sir. You can step down.
Witness leaving courtroom. Come to order. Part 59 is back session.
Mr. Steinglass, are you ready?
Yes, Judge. Thank you for the opportunity.
Let's get the witness.
Witness entering, please. Whereupon the witness, Keith Davidson, having been previously duly sworn and or affirmed, witness stand. Jury entering resumes whereupon the jurors and the alternate jurors are present and properly seated. Case on trial continues. All parties are present. Appearances remain the same. Jury is present and properly seated.
Mr. Steinglass.
Thank you. Thank you for that as well. Hello, Mr. Davidson.
Hello.
On cross-examination, Mr. Bove asked you several questions about a recorded conversation that you had with Michael Cohen on April 4th of 2018. Do you remember that?
Yes.
And at the time, as of April 4th of 2018, had Stormy Daniels hired Michael Avenatti?
I believe so.
And was Michael Avenatti suing you and Michael Cohen at the time?
Yes.
That you had this conversation with Michael Cohen?
Yes.
Would you like me to put or hand you copies of some of the transcript segments that Mr. Bove showed you?
Yes, please.
I'm going to hand you defendants F-17CT and defendants F-17-8ET. @ET.
Whereupon the documents are shown to the defense and then shown to the witness.
Thanks.
You have them?
Yes.
Okay, so let's start with F-17CT. Mr. Bove asked you if you said to Michael Cohen, and now that Avenatti has really driven a serious wedge in between Stormy and Gina, Avenatti is leaning on Gina and saying, basically we're lying. We know we're full of shit in the media. We know that she was never threatened in Las Vegas. We know all these things. What did you mean when you said that?
I meant that Avenatti was trying to persuade Gina's testimony.
So, were you in any way acknowledging that you were lying?
No.
Were you in any way acknowledging that Stormy Daniels was never threatened in Las Vegas?
No.
Is it your belief that, or is it your meaning that when you said that, you were talking about the things that Avenatti was going to allege or was alleging?
That's correct.
Similarly, Mr. Bove showed you, or read you, or played for you, or all of the above, a portion of the same call and gave you the transcript F-17-ET. Can you take a look at that one, please?
Yes.
And he asked you if you said, I wouldn't be the least bit surprised if he comes out and says, let me just stop myself for 1 second to ask, who is he in that?
Anthony Kotzeff.
Okay. I wouldn't be surprised if he comes out and says, you know what, Stormy Daniels? She wanted this money more than you could ever imagine. I remember hearing her on the phone saying, you fucking Keith Davidson, you better settle this goddamn story because if he loses this election, and he's going to lose, if he loses this election, then we lose all fucking leverage and this case is worth zero. Mr. Bove asked you if you were discussing the Stormy Daniels case when you said these things to Michael Cohen?
Yes.
Are you at all saying that Stormy Daniels said those things?
It was my understanding at the time that this was April 4th and that Anthony Kotzeff was about to give a media interview, in sum and substance, in alignment with this text.
Just to be very clear, you were not telling Michael Cohen that Stormy Daniels was talking about the election and how she's going to lose her leverage after the election. It was your understanding that those were things that Anthony Kotzeff was going to say?
Correct.
You testified on direct examination that you had an opportunity to review documents and exhibits that were contained on a thumb drive. Do you remember that?
Yes.
Did you have a chance to listen to another recorded conversation from October 16th, 2017 between yourself and Michael Cohen that has been marked for identification as People's Exhibit 265?
Yes.
Do you know who made that recording?
Michael Cohen surreptitiously made the recording.
When you say surreptitiously, did that mean you did not know you were being recorded?
I did not know I was being recorded.
Does that fairly and accurately depict a conversation that you had with Michael Cohen on October 16th, 2017?
Yes.
I offer it into evidence.
No objection.
Accepted into evidence.
Similarly, did you also have the opportunity to review what has been marked for identification as People's Exhibit 267?
Yes.
Is that a transcript of the recorded phone conversation that we just admitted as People's Exhibit 265?
Yes.
Have you compared the transcript to the recording itself?
I have.
Is it accurate?
Yes.
I offer that into evidence.
Can I have 1 moment to confer with Mr. Steinglass?
Yes.
Whereupon counsel confer.
No objection. Thank you, Judge.
People's 267 is accepted into evidence.
What I would like to do, please, is display People's 267 pages 10 to 11, while I'm playing a portion of 265 from 11 minutes and 13 seconds into the call through 13 minutes and 33 seconds into the call, and we can display this to everyone, please.
Whereupon the audio exhibit is played in open court, and the exhibit is shown on the screens.
It's my entire family. There's nobody's thinking about Michael. You understand? And despite what, like, for example, what the earlier conversation, and who else would do that for somebody? Who else?
Yeah.
I did.
Yeah.
Because I care about the guy.
Right.
And I wasn't going to play penny wise, pound foolish.
Right.
Right. And I'm sitting there and I'm saying to myself, what about me?
Yeah.
What about me? And I can't even tell you how many times he said to me, I hate the fact that we did it. And my comment to him was, but every person that you've spoken to told you it was the right move.
it's tougher for people in opposition to as lawyers, right? And he's your client, so now he controls the privilege. So even if you wanted to go write a book, you probably couldn't.
Nah, I could.
Yeah,
I could. That's not a privilege,
right? So, yeah, it's tough. And you didn't ask for any of this.
No.
You just happened to be.
Well, actually, I did. I mean, look, I did ask for it because, in all fairness, I started the whole thing. I started the whole campaign, so maybe I did ask for it.
Right. How is he taking care of you, or what?
No.
That sucks.
No.
That's awful.
And not only that, it's like everyone around him is, in my opinion.
So the portions of that tape that are attributed to Keith, is that your voice?
Yes.
And the portions of the tape that are attributed to Michael, is that Michael Cohen's voice?
Yes.
I want to blow up a particular paragraph here at the top of page 11. Do you see the paragraph we're blowing up?
Yes.
When Mr. Cohen said to you, I can't even tell you how many times he said to me, who did you understand he to be a reference to?
Mr. Trump.
And what did you understand, I hate the fact that we did it, attributed to Mr. Trump, to be a reference to?
I attributed that to be a quote from Mr. Trump.
About what? Did what?
The Stormy Daniels settlement.
1 minute, please.
Whereupon the people confer.
No further questions.
Thank you. Mr. Bove, anything else?
Yes, please.
Mr. Davidson, you don't know the day of that recording, do you?
Not offhand.
And so when you're interpreting words of Michael Cohen without understanding the date, you don't know what conversations had taken place by that time between you and Mr. Cohen, do you?
I don't understand your question.
You have no frame of reference for when that was said in the context of all the other events that you testified about today, right?
No, I have a pretty good understanding of the context.
My question is not the date, sir. You don't know the conversation occurred as you sit here, do you?
Not offhand.
And you were asked questions by Mr. Steinglass about the recordings that you and I discussed, right?
Yes.
And those are recordings that had your voice, correct?
True.
And Mr. Cohen's voice, correct?
True.
And the transcripts were accurate, and you followed along with those, right?
Yes.
The defense offers F-15A and the corresponding transcript, F-17A and the corresponding transcript, F-17C and the corresponding transcript, F-17E and the corresponding transcript.
Any objection?
No objection.
Accepted into evidence.
Mr. Bernick, let's start with F-15AAT on the screen. This is in evidence so the jury can see it.
Whereupon an exhibit is shown on the screens.
And you can play the corresponding call, please.
Whereupon an audio exhibit plays in open court.
Avenatti's lying his ass off, as you know, and I know, and Gina knows. And Stormy knows. And Stormy's lying. Right?
Are you speaking with Gina?
On occasion. We went a long time without speaking. You know, Gina brought Stormy to Avenatti. And we went a long time without speaking. And now that Avenatti has really driven a wedge, a serious wedge, in between Stormy and Gina, Avenatti is leaning on Gina, saying, you know, basically, we know we're lying. We know we're full of shit in the media. We know that she was never threatened in Las Vegas. We know all these things.
Now I'd like to publish to the jury F-17CT, that's the transcript, and play the corresponding audio, F-17C.
Whereupon the exhibit is shown on the screens and the audio exhibit plays in open court.
Now if we could please publish F-17R.
Whereupon an exhibit is shown on the screens.
And please play the corresponding audio.
Whereupon an audio exhibit is played in open court.
$130,000. Was there ever any indication that the money was coming from him? And I said, no. They said, was there ever any indication that Michael Cohen needed authority from Donald Trump before he made that payment? And I said, no, it was never discussed. They said, did you ever ask Michael Cohen what conversations he had with Donald Trump about this payment. I said, no. And why would an attorney ever ask opposing counsel what kind of conversations they had with their client? Like, that's between them. To the extent that it happened or didn't happen, I have no idea. But as far as my conversations with Michael Cohen go, it was solely about negotiating a deal and completing a deal that two consenting adults, or that my client wanted and his entity wanted. That's it. What else did they ask? That's pretty much it. I think it's going to air later today.
Oh, yours is going to?
Yeah. And I think, look, it's the truth, Michael. You know that. But I think that you and I both want the truth out there.
I do, for both of us.
If we can, please, now publish the last defense exhibit, F-17ET.
Whereupon an exhibit is shown on the screens.
Zoom in on the text, please, and then play the corresponding audio.
Whereupon an audio exhibit is played.
I just didn't want you to get caught off guard, and I wanted to let you know what was going on behind the scenes. And I would not be the least bit surprised if you see in the next couple days that Gina Rodriguez's boyfriend goes out in the media and tells a story that Stormy Daniels, in the weeks prior to the election, was, basically yelling and screaming and calling me a pussy.
Can I ask you a question? Right.
No, hold on 1 second. I wouldn't be the least bit surprised if he comes out and says, you know what, Stormy Daniels, she wanted this money more than you can ever imagine. I remember hearing her on the phone saying, you fucking Keith Davidson, you better settle this goddamn story, because if he loses this election, and he's going to lose, if he loses this election, we lose all fucking leverage. This case is worth zero, and if that happens, I'm going to sue you because you lost this opportunity. So settle this fucking case. That's a far cry from being, bullied and pushed into settling a case.
Right.
Am I understanding you correctly in saying that you believe that statements that Stormy Daniels made to you about using the election as leverage are subject to attorney-client privilege? Objection.
Sustained.
The agreement that you signed in connection with the Stormy Daniels settlement used the initials DD, right?
Yes.
That was in a decoded side letter, was in connection with President Trump, correct?
Yes.
A man you've never talked to, correct?
Correct.
Objection.
Overruled.
And a man you've never been in the same room with before Tuesday, is that correct?
Yes.
I have no further questions.
Anything else?
No, thank you, Judge.
You can step down.